What if one day you're stuck in a hospital bed, unable to speak, and the doctors are asking your family what to do next, but no one has the legal power to decide? It happens more often than you'd think. And in those moments, not having the right document can cause delays, confusion, and sometimes irreversible damage. That document is called a power of attorney. But do you really need one? Or is it just something for the elderly and the ultra-rich? Stick around, because by the end of this video, you'll not only know what a power of attorney is, you'll understand whether you actually need one, how it works, and the simple steps to get it done. And trust me, the part most people get wrong could end up costing you everything. Let's break it down. Number 1. What is a power of attorney, really? A power of attorney, often shortened to POA, is a legal document. It lets you give someone else, called your agent or attorney in fact, the power to make decisions on your behalf. That can mean managing your money, paying your bills, selling your car, even making medical choices. For you, it does not mean they take over your life. Think of it like giving someone a spare key to your house. They don't own the house, but they can step in if you're away or unable to open the door. Let's say John is deployed overseas for military duty. He gives his sister a power of attorney so she can pay his mortgage, access his bank account, and sell his old truck while he's gone. That's the power of PO, literally. Number 2. There's more than one type of power of attorney. This is where it gets interesting and confusing if you're not careful. There are several kinds of POAs. But let's keep it simple. The two big ones are financial power of attorney, handles your money stuff, like paying your rent, managing investments, or handling your taxes. Medical power of attorney makes healthcare decisions if you can't speak for yourself. Then we've got durable POA, which stays in effect if you become mentally incapacitated, and springing POA, which only kicks in after you become incapacitated, not before. Let's take an example. Sarah gets into a car accident and is in a coma. If she had a durable medical POA, her mother could legally speak with the doctors and authorize treatments. But if Sarah didn't have one, the hospital may require a court order before anyone can step in. That could take days, time she doesn't have. Number 3. Who should actually get a power of attorney? Here's the truth. Not just seniors. Everyone over 18 should consider it. College students, young adults, military personnel, even digital nomads. Why? Because life doesn't give warnings. Let's say a college kid named Alex goes backpacking in Europe and ends up in a foreign hospital after an accident. His parents try to access his USA-based bank account to pay the hospital bill. But without a POA, the bank says sorry, not allowed. Total nightmare. Having a POA can save you from that chaos. Number 4. When does a power of attorney actually kick in? This depends on the type you choose. If it's an immediate POA, it's effective as soon as it's signed and notarized. If it's a springing POA, it only activates once a doctor declares you incapacitated. But here's the catch. Proving you're incapacitated isn't always simple. Imagine the delays while the bank waits for 2 doctors to sign off, all while your bills are stacking up. That's why many people go with durable POAs. They're reliable, stay active, and don't leave you hanging when you need them most. Number 5. Who should you choose as your agent? This might be the most important decision. You want someone trustworthy, responsible, and available. They don't need to be a lawyer or a financial expert, but they do need to have your back. Most people choose a spouse, parent, adult child, or lifelong friend. Let's say Mike chooses his best friend Jake to be his POA because Jake knows how to handle money, but Jake has a gambling problem. Yikes. Now Mike's life savings could disappear, legally, so don't pick someone just because you're close. Pick someone who will protect you. Number 6. What can your agent actually do? Good question. And the answer depends on how the POA is written. You can give them broad powers or be very specific. For example, Jane can manage all my bank accounts, or Jane can only access my account to pay rent and utilities. You're in control. It's like giving someone a remote control with certain buttons locked. And remember, they have to act in your best interest. If they don't, it's considered financial abuse. And yes, they can get sued. Number 7. What happens if you don't have a power of attorney? If something happens to you, like a stroke, accident, or mental illness, and no POA exists, the court may appoint a guardian. That guardian may be a stranger, a person you don't know or don't trust. And worse, your family might have to go through a long Expensive process called guardianship or conservatorship that could take weeks or months. And while that's happening, your mortgage doesn't wait. Your credit cards don't pause. Your medical treatment may hang in limbo, all because one paper wasn't signed. Number 8. How do you create a power of attorney? Thankfully, it's easier than you think. There are 3 main steps. Step 1. Decide which kind of POA you need: medical, financial, or both. Step 2. Choose your agent carefully. Step 3. Get the form. Many states offer free POA templates. You can find them on your state government website. Once filled out, get it notarized. Some states also require witnesses. Example: in Texas, you need a notary and 2 witnesses for a medical POA to be valid. And always keep multiple copies. One for you, one for your agent, one for your doctor or hospital, and maybe one with your attorney or financial advisor. Number 9. Can you cancel or change your power of attorney later? Absolutely. You're in charge, always. If you decide to revoke a POA, you just sign a revocation form and notify all parties involved. Let's say Rebecca names her brother as her POA at age 25. At age 35, she realizes he's moved overseas and isn't responsive anymore. She updates her POA and names her partner. Instead, simple and smart. But don't forget to destroy old copies and tell your bank, your doctor, and anyone else who had the old one. Number 10. Common mistakes people make and how to avoid them. Mistake 1. Naming someone who's not trustworthy. Mistake 2. Waiting too long. Mistake 3. Not updating it after a divorce or major life event. Mistake 4. Thinking a will covers the same thing. It doesn't. It will goes into effect after you die. A power of attorney works while you're alive and possibly unable to speak. Think of your POA as your voice when you lose yours. Number 11. Real-life stories that might hit close to home. Meet Donna. She's 45, healthy, and a single mom. She didn't think she needed a POA. Then she had a stroke during a hiking trip. Her teenage son couldn't make any decisions. Her sister had to go to court twice just to access her medical records. Weeks passed before she could legally manage Donna's finances. Total stress. All avoidable with a simple document. Now meet Mark and Ashley, a married couple. Mark gave Ashley POA rights, and when he was hospitalized for surgery complications, she was able to quickly access their bank, talk to doctors, and keep their life running. Same emergency, different outcomes. Number 12. Let's bust some myths. Myth 1. Only old people need a POA. Wrong. Accidents don't check your birth year. Myth 2. If I'm married, my spouse automatically gets to decide. Wrong again. In many cases, your spouse cannot legally make medical or financial decisions without a POA, especially if accounts or assets are in your name only. Myth 3. It's expensive. Not true. In most states, you can create a valid POA for less than $50 and sometimes for free. That's cheaper than a single Uber ride to the ER. Number 13. Do power of attorney documents work in every state? Not always. Each state in the USA has its own laws and requirements for POAs. A document valid in California might not meet all the rules in Florida if you move to another state. It's a good idea to update your POA, or at least have a lawyer review it to make sure it's still valid where you live. Let's say you created a POA while living in New York, but now you've retired in Arizona. Arizona law may require different wording or witness rules. One small mismatch could make your document useless when you need it most. Better to fix it ahead of time. Number 14. Can you have more than one power of attorney? Yes, and in some cases, it's smart to do so. You can have separate POAs for different roles. For example, you could name your brother to handle your finances, and name your best friend, who's a nurse, to handle your medical decisions. Just make sure their powers don't overlap or contradict each other, and always communicate clearly with each person so they know what's expected. This way, no one is surprised or confused in an emergency. Number 15. Can you name more than one person as your agent? Yes, but be careful. You can name multiple agents to act together or separately. If they must act together, that means both. People have to agree on every decision. This can help keep one person from going rogue, but it can also slow things down. Let's say your 2 adult children are co-agents. If they disagree on how to handle your care, things can stall. fast. On the flip side, if you allow them to act independently, one could make a big decision without the other knowing. So if you're naming more than one agent, be clear about how they're supposed to work together and include backup agents just in case someone is unavailable. Number 16. What is a limited power of attorney? A limited power of attorney only gives someone power for a specific task or time. Example, you're selling a house while living out of state. You give your cousin a limited POA to sign closing documents on your behalf, and that's it. Once that task is done, the POA ends. This is great when you need short-term help without giving someone full control over your life. It's like giving someone a hall pass. It only works for one hallway and only for a set time. Number 17. Do banks and hospitals always accept POAs? You'd think so, but not always. Some banks have their own POA forms and may reject generic ones. Hospitals may question older POA documents or those that aren't clear. That's why it's smart to check with your bank and medical provider ahead of time. Ask if they'll honor your document or if they prefer their own version. Getting this sorted early can prevent future headaches. Number 18. What's the difference between a power of attorney and a living will? Great question, and it trips people up all the time. A living will is a document that spells out your wishes for end-of-life care. It says things like, if I'm in a coma, I don't want to be kept alive on machines. A medical POA, on the other hand, names a person to make all healthcare decisions for you, not just about life support. You can and should have both. The living will gives guidance. The medical POA, it gives someone the legal authority to act. Together, they form a powerful plan for your healthcare future. Number 19. Can a power of attorney be used to steal from you? Sadly, yes. And it happens more than you'd think. That's why picking the right agent is critical. Abuse of POA powers is a type of elder financial abuse, and it's a growing problem. There have been cases where agents drained bank accounts, sold homes, or took out loans, all legally, because they had POA. To protect yourself, choose wisely. Set clear limits and review your POA regularly. And remember, just because it's legal doesn't mean it's right. Your future is too important to leave in the wrong hands. Number 20. Should you store your power of attorney online? It's smart to keep a digital copy, but also have hard copies ready. You never know when a hospital or bank will ask for a physical, signed version. There are online legal vaults and estate planning apps that store your POA securely. Just make sure your agent knows how to access it when needed. Also, avoid storing the only copy in a safe that no one else can open. If no one can find it, it might as well not exist. Access matters. Number 21. Should you talk to your family about your POA? Absolutely. And the sooner, the better. This isn't a surprise reveal kind of moment. Your agent should know their role, understand your wishes, and feel comfortable stepping in when the time comes. Your other family members should also be aware to avoid confusion or conflict. Many families are torn apart because no one talked things through, and then something went wrong. A simple conversation today can avoid a legal battle tomorrow. Number 22. What happens to your power of attorney after you die? It ends. A POA is only valid while you're alive. The moment you pass away, it's no longer in effect, and your will takes over. This is why estate planning involves both documents. Your POA protects you during life. Your will protects your wishes after death. They're teammates, not substitutes. So, do you really need a power of attorney? If you want someone to protect your money, your health, and your peace of mind when you can't speak, then yes. And if you want to avoid the stress, delays, and legal mess that come from not having one, then it's not just smart, it's essential. Now, here's a question for you. If something happened tomorrow, who would speak for you? Let me know in the comments.